Okay, we're back to thinking like a lawyer, or TLAL as I call it. Today we're talking about non-solicitation agreements. And we're talking about non-solicitation agreements because I have a lot of people who reach out to me all the time to understand these documents. So today's broadcast is going to be breaking down what these documents are and how you can think about them. So first things first, a non-solicitation agreement is a type of post-employment restrictive covenant. We've talked about post employment restrictive covenants before, but let's do a quick little rehash. Post employment, you are no longer working for that company. Restrictive, liberty that you had is taken away. And covenant, a contract. The one we talked about before were called non competition agreements. The non competition agreement is a type of contract that a person may sign that would prohibit them from doing certain types of work, not able to do the trade that they practice because they have agreed to not do that for a period of time. Like everything else, these contracts have to be reasonable. They have to serve a business purpose. And there's a lot of reasons why an employer wants their soon to be employees to sign non solicitation agreements. So let's break down the non solicitation agreement. And if you have any questions, put them in the chat. I think they'll work. Maybe they won't. Who knows? A non solicitation agreement has to be reasonable in terms of duration. How long are you bound by this document? How long will you not be able to solicit? It's also going to be about geography. How expansive is the thing that you're looking to do? Now, in non solicitation agreements, there's really two functionalities. There's non solicitation of employees or your colleagues, your coworkers, and there's non solicitation of your customers. And that's where these things get so interesting. Most employers don't want you to work for them and then steal their customers. That makes a lot of sense. And people are the most valuable resource of any company. Oh, Trey Griggs, testing, testing, 1, 2. Yes, I'm getting there. We're on our way to being professional at what we do here at Armchair Attorney. Now, here's the thing. When you go to work for a company and they want you to sign a post-employment restrictive covenant, non-competes, non-solicits, non-disclosures, and non-disparagement, you want to have time to review the document. You want to make sure that you are signing something that you agree with. And if you don't have the time, it's probably not something you should execute. Now, many companies are getting away from non competition agreements. They think that the best option is a non solicitation agreement. Effective salespeople, truly effective salespeople, you don't get to take their contacts. You get to rent them. You rent those contacts as an employer. So here's where it gets kind of dicey. What is it that you can't solicit? What is you can't do with a non solicitation agreement? Really, it depends on the document you're presented with. With a non solicitation agreement, you are not able to go back to your former coworkers and tell them, come work for me, come join my team. You can't do that. But nothing stops that former colleague from going to work at your company anyway, from going to a job board and finding an application. The non solicitation agreement is what binds you, the individual. It's restricting what you do. It can't restrict what your customers do, and it can't restrict what your former coworkers do. And that's why these aren't, as in my mind, as dangerous as non-competition agreements. The non-competition agreement stops you from doing what you're good at because you've agreed to do that. The non-solicitation agreement, oh, that's a great question from Marshall. Interested in thoughts on moonlighting clauses. So let's break down what a moonlighting clause is. When you're talking about moonlighting, the whole idea is doing something else while you're employed with somebody currently. What that means is, let's say you're a mechanic and you're working for a shop 40 hours a week, but in your free time or in your spare time, you have the ability to fix someone else's stuff on your weekends or something. That's what a moonlighting clause is designed to prevent. There's a good reason for these things from both perspectives. One thing is your current business doesn't want you to go make money for somebody else, let alone yourself. That's why in almost every context of moonlighting clauses, you're going to be required to disclose the moonlighting that you would be doing to your current company. The current company has an interest to know about this. Now, I use the example of mechanics because if you're a mechanic and you're moonlighting and you hurt yourself, and then you go to work the next day and you injure it again, now your current company is going to pay potentially that workers' compensation claim from your moonlighting. It's a lot of other things that go into that, but that is one of the things about moonlighting clauses. So, my thoughts on moonlighting clauses, I generally think they're reasonable, provided that they have the ability for the company, the individual, to continue to do moonlighting if they disclose that to their employer. But I can see it both ways. So moonlighting is an interesting type of restrictive covenant that is in almost every single contract. What we typically see as a lawyer in this space is that you want to give your full attention to your company, your full ability to be creative and be productive to that company. They are getting all of you, even if you don't want to give all of you. But that's essentially what the moonlighting clause does. Now, back to non-solicitation agreements. If you have a book of business, if you have clients that you know, and you're faced with a non-solicitation agreement, it is okay and it is encouraged to say, hey, you know what? I actually have my own clients, and I want to make sure that these clients specifically are not part of this non-solicitation agreement. You can do that. Like I said before, every contract is negotiation. Every discussion about employment rules is a negotiation, and you should be able to negotiate these things. The other thing about non-solicitation agreements, which is the same with the non-competition agreements, is that these things are much more enforceable when you have separate consideration. So separate consideration, we've talked about it before, but I'll take a moment and tell you about it. A contract, a contract requires an offer, an acceptance, a performance, and consideration. The consideration is the payment. That's what gets the performance to happen. So if you don't pay someone separately for the non-competition or non-solicitation, then you will find those contracts are less likely to be enforced. Keep in mind, anything that you sign is probably going to be enforced against you. And it's important that you know that if you sign it, it's probably going to be enforced against you. So what happens? You have a non-solicitation agreement and you want to get a new job. Now that creates some challenges because your future employer will almost always ask, are you subject to any restrictive covenants? Non-competition, non-solicitation, non-disclosure, non-disparagement. Nearly every single person in the private sector has some iteration of a post-employment restrictive covenant. I've seen numbers up to 30 to 40 million people in all sorts of industries signing non-solicitation, non-competition. These are pervasive and, generally speaking, not something that I'm a super big fan of. I prefer when workers have the ability to take their skills to any place they want to go. But this is what makes non-solicitation not as frightening as the non-competition, because your customer can follow you. You don't have to call the customer and say, here's where I'm at now, come work with me. It goes back to this question of what is solicitation. Now, this is not intended for legal advice. Nothing that I say here is meant to establish an attorney-client relationship. Don't take legal advice from a podcast or a webcast or any iteration of something like this. If you have a question, get a lawyer. They'll help you. But if you were to put an advertisement up, let's say you changed jobs and you made a big LinkedIn post, and your former customer says, hey, I'd love to learn more about it, and you're locked into a non-solicitation agreement. Is that post solicitation? I don't think so. I think that's not solicitation. Maybe companies would think that that is solicitation. Maybe they would try to sue you. And that's the frightening thing. It gives a reason for your former employer to sue you, even if they're not right, even if you didn't solicit, but you signed that document. They could still make a claim against you and say, hey, you should pay me back. You should not do this job. And they'll sue your current employer, your new employer. And they might say, you, new company, are tortiously interfering with the contract that I have with my former employee. So, non-solicitation agreements, they are post-employment restrictive covenants that will stop you from calling on your former coworkers and stop you from calling on your former customers for a period of time, for a geographic area, or for a particular type of business. So, for example, if you went from being a freight broker to being a tire broker, could you call your old customers? Generally, probably you could. Probably you could. Maybe not. These contracts are all governed by state law. These contracts are all given to you when you join a new company. And when you join a new company and you're understanding what you're expected to sign, the questions that you should ask is, what types of contracts must I sign to work with you? If you see a non-solicitation agreement, the thing to do is say, I would like to have as much time as I can to review this. If you can, refuse to sign it. Say you don't want to and see what they say. If they say you have to, limit how long it goes for. Limit what types of customers it means. The point of the non-solicitation agreement is to protect the business from all of their clients or all of their coworkers from leaving to go work for a new company. It's designed to protect the business. Nothing about the non-solicitation agreement or the non-competition agreement is designed to protect the employee. There was a great case that I read a couple days ago about sandwich shops that made sandwich makers sign non-competition agreements. And they were required that they couldn't make sandwiches in any place within 3 miles of the place they currently worked out of. That's pretty bizarre. It's pretty terrible. I have a comment here. Let's take a look. This is from Samantha Jones. If a customer is working with a company because of the person they work with, that business will follow them if they go somewhere else. That's why companies need to treat their people as their assets. I could not agree more strongly with Samantha here. Successful businesses are comprised of 3 specific things: technology, processes, and people. If you're missing any of these, you will struggle. If you're missing more than 2 of these, you have a very big problem. Effective people will go to different organizations, and customers and coworkers may follow them, but it doesn't mean that they've broken the non-solicitation agreement. So when I talk with people about these post-employment restrictive covenants, the non-solicitation of your former coworkers is pretty reasonable. I understand that. The business doesn't want you to figure out who are the most productive people. We have that 80-20 rule where 20% of the people do 80% of the work. If you can figure out who those really key people are, you can cripple a company. And that's why ultimately I'm pretty okay with non-solicitation of former coworkers. The non-solicitation of customers is different, mostly if you've brought your own book of business. There's been plenty of times for me personally, I will go to talk with a company and they'll say, well, you can work with us, but you have to sign this non-solicit. And I'll say, well, I have a lot of my own customers. I'm not going to give them to you. You can borrow them while I'm here, but I'm not going to have them as part of this. I'll write in the ones that are mine. So that's something you can do too. Ultimately, these post-employment restrictive covenants are designed to limit what you do after you've left employment. They can go on for long periods of time, 12 months, 18 months, 24 months. And I look at these things all the time. And oftentimes when an employer presents these documents to you, you are not given enough time to review them. And because you can't review them with the right amount of time, you don't get to really understand what you're getting into. Anytime an employer asks you to execute a document and they don't give you time to review, you need to ask for time to review. I will fundamentally tell you, you deserve more time. And if you can, don't sign the documents. If you can't get away without signing them, then you need to tell them what limitations you have. At the end of the day, you have so much power. Unemployment is lower now than it's been in a very long time. And because of that, talent has the ability to go anywhere in the world. It's not just work from home. It's work from anywhere. And if you can work from anywhere, your ability to add value to an organization is massive. And if there are organizations that you're talking to that say, well, here's what you have to sign to agree to work with us because we don't want you to leave and take business from us. It's important to note that you have the power to say no. You have the power to say, look, I don't want to sign this. I think it's stupid. And they might say, I'm sorry, you have no choice. But a lot of times they will work with you and they'll say, you know what? This time around, I'll agree. I won't end up signing that document. There's another comment from Marshall. Techs take other good techs all the time. Oh, absolutely. Look, I've been in the maintenance business for a long time. I have seen companies put non-competition and non-solicitation agreements on mechanics and trying to make it so a mechanic can't go out and earn their living. If you are a company, or if anyone knows of companies that are making their mechanics sign non-competition agreements, let me know. I would love to just talk about that and go with that as a topic for a little bit. But for technicians are just like anyone else. They follow the people that they believe in. They follow their leaders. If a leader moves to a new company and that leader is bound by a non-solicitation agreement, they don't have to solicit your people to make them leave. Those people will leave. The people will follow the leaders that they believe in. That's why non-solicitation agreements aren't nearly as frightening as they might otherwise look from first blush. So let's do a final recap. If there's any other comments or questions in the chat, please feel free to add them. But I'll just kind of do a little roundtable. Final piece. Non-solicitation agreements are a cousin or a brother of a non-competition agreement, a post-employment restrictive covenant. These post-employment restrictive covenants are designed to limit what you are able to do after you've left the business. In the context of a non-solicitation agreement, you have to understand how long this non-solicitation agreement goes for. Does it apply to the coworkers or does it apply to the customers? If it applies to the customers, are these customers ones that you've worked with directly, or is it any of the customers the company has? If you have your own book of business, you should always seek to add those as exemptions in the non-solicitation agreement. It is completely reasonable for you, in the context of a non-solicitation agreement, to say, pay me for the contract. You want me to do something for you after I leave, and you're not going to pay me for that? No, I don't want to sign that. That's the challenge with these documents. You don't get to just give someone a document and make them sign it. So if you're currently employed with a company and you have a non-solicitation agreement and you want to leave, nothing will stop you from leaving. The things you have to understand is, if you're going to leave, what your limitations are. Always consult with an attorney, and most attorneys will meet with a client for free to understand the consultative service. What is it you're looking to do? Sometimes you have to pay a nominal fee, and that's reasonable when you're trying to understand what limitations you currently have. Because when you go work for a new company, that new company will absolutely ask you, what types of contracts are you bound by? And if you don't disclose the things you're bound by and they find out, they will fire you because they will not be part of litigation if they're not aware of the contracts you have. Finally, these are contracts that you can negotiate. You should negotiate. Negotiate everything. You negotiate for your salary. You should negotiate on every topic of every type of contract that you are required to sign. Finally, if you join a new company and you see that they have a non-competition or a non-solicitation, say no. Say, I don't want to sign that. I don't believe in it. See what they do. Like I said before in previous videos, I had coworkers that had signed documents and I had coworkers that didn't. And they were the same level because sometimes you just negotiate and push back. And that's what happens. Another quick comment here from Marshall. Let's see what he got here. In this employment market, everything is on the table for negotiation, especially in our industry. Absolutely. Absolutely. The worker has more power now than we've had in a long time, and it's been a long time. You have the ability to use your leverage as a skilled person to get the best deal possible. You are not doing your company any favors when you sign a whole bunch of documents that you don't understand. Your company really does want you to understand what you're signing, and they definitely expect you to be bound by those things. So at the end of the day, when you're sitting in the room and you have that contract, ask for time to review it. If you can, get an attorney. If you can't, just refuse to sign it. Say you don't want to and see what happens. Maybe you can push back for shorter periods. Maybe you can push back for limitations of who those customers are. Generally speaking, I'm not against non-solicitation of former coworkers. I completely understand the value of those things. But remember, it is about what you personally do. You can't go call, text, or email your friends from your old job and say, come work for me. It's going to be great. That's going to be solicitation. It'll be a problem. But there is nothing that stops your former coworkers from trying to join the firm that you've joined. And there's nothing that would stop your former customers from saying, oh, This guy or gal went over to that company. I want to go learn about them because these contracts, these non-solicitation contracts, cannot bind third parties that are not part of those deals. That's why ultimately I'm not as concerned about non-solicitation agreements. Hopefully, this was instructional. Hopefully, this was helpful to understand what it is that is a non-solicitation agreement, a post-employment restrictive covenant. We are close to 20 minutes. We will go ahead and call it for today. As always, thank you for watching. If you like these videos, you find them interesting, or there's other legal topics or topics in general you'd like to have a better understanding of, let me know. The last little caveat I will say is a couple weeks ago, we did a video on Elon Musk buying Twitter. That is an ongoing challenge. It hasn't happened yet. In fact, it is now on pause. Ostensibly, the pause is related to Elon Musk wanting to get verification of how many of these current users of Twitter are actually robots. They believe less than 5%. That is why they have opted not to make the deal proceed. There's other things we should talk about. So the Securities and Exchange Commission, as we talked about in our first video, shareholders from Twitter sued Elon Musk. And they said, you were supposed to tell us when you hit 5% ownership. You didn't tell anybody. And because of that, you bought more shares at a lower price. Because the moment you disclosed it, then the stock price went up. Well, now the Securities and Exchange Commission is opening a probe against Musk based on that failure to disclose. So there is a lot of really interesting moving parts. Twitter shares were down 20% from what I saw. So there is certainly some issues there. I got a quick little thing from Tony Pasalacqua. Thank you so much, Tony. Very informative. Thank you, Matt. I am always happy if anybody finds what I say in these videos to be helpful or instructional. That makes me really happy. It makes me know that at least I'm doing something somewhat useful. And I will continue to do this as long as you guys will listen. So thank you again for making the time. And as always, have a great day. Have the best weekend possible. Thank you so much. Bye. And then I hit the end broadcast button and it goes off. That's what I do. I got some text messages. This is a busy day. Goodness. Oh, we're still on. Yeah, of course we are. All right. We're having fun. Goodbye, everybody.